with the defendant intending to commit a felony, but he was convicted on first-degree premeditated murder. The issue with him being convicted on first-degree premeditated murder is the premeditated jury instruction is in fact erroneous. I don't believe anybody's disputing that. Opposing counsel's not disputing that. This court has actually found that instruction to be erroneous on plain error. So it is significantly and tremendously erroneous. So I don't know if we have to go much further past that as the issue, but that is the issue. And the reason it's such a material issue is if the defendant is convicted under the count in which the premeditated first-degree murder instruction is plainly erroneous, but when he's charged under felony murder and he's not convicted at all, I think that necessarily tells us that the issue with the way that this premeditation instruction was given is the problem. And I don't know if there is any other reasonable alternative other than to allow this matter to be remanded back so that he can be heard on that, if nothing else. We knew as early as the year 2006, State v. Compton, and that's cited to on page 12 at the top of my brief, that there was an issue with this premeditation. I believe that the arguments made by opposing counsel and even referenced by trial court is that, well, maybe the trial counsel was not aware of it, or maybe there was not enough notice because there were questions about whether or not this decision would, whether or not this was whether there was a final answer given on premeditation. The problem is that argument is creative. Even trial counsel is not arguing that. Trial counsel is cited to in the brief, and it was said under oath at the hearing, he would have raised any issues related to jury instructions had he been aware, had he knew about them. So this is, again, an issue so significant, it's been found to be an issue on plain error. There's no real argument to avoid this issue. Now,
well, let's take the Compton case. That, as the state points out, that was dicta in Compton, right? And
correct.
Compton is an unpublished case.
Correct.
So it not being the holding, you're stating that trial counsel should have known and read the tea leaves in Compton to say this would be error?
Yes. So for two reasons. One is because whether or not it was dicta, the law didn't change. That has always been the law, that jury instruction is improper. It was clarified when there was prior rulings, but at no point was that jury instruction ever proper. So a reasonable trial counsel should have been able to read the jury instruction and understand it was not proper. That's issue number one. But issue number two, even if it wasn't dicta, I believe what's relied on is the Sykes opinion that the court relies on of July 14th of 2011. And essentially the argument being made is, hey, the motion for new trial was filed July 31st of 2009. Sykes wasn't decided till July 14th of 2011, so basically, wouldn't that mean that there'd be no mistake or issue with trial counsel? Well, one, again, as I previously stated, it was always an issue whether it was raised as dicta or not raised at all. It was not a proper instruction. It was improper based on plain error, so it was always an issue. That's issue number one. Number two, trial counsel is also the appellate counsel in this. Well, why is that relevant? It's relevant because the opinion on this case was filed July 29, 2011. The Sykes case, which it sounds like even if everyone's at least agreeing that that is a clear indication of when you would have known outside of knowing because of your skills or your background as a trial attorney, specifically with this trial counsel having significant background experience. And in addition to that, if you read the transcripts from the post-conviction hearing, he did allude to the fact that he understood there was an issue or something going around about premeditation. So he said he threw something in about premeditation, but he didn't know exactly what the issue was. So again, I would submit it was not unreasonable or unknowable, but let's just go with that for a moment. Well, on July 14, 2011, the Sykes case comes out. Well, the opinion in this matter isn't filed until July 29, 2011. So once the Sykes case comes out and it's not dicta, trial counsel would have been on notice prior to the ruling. Now, to the extent maybe the argument is, well, that's such a short window of time, he would have needed then to file something with this court, but let's say he didn't and didn't think about it then. Well, if you look under Rule 39 for a petition to rehear, it specifically and explicitly covers these type of scenarios. He could have then, while still on appeal, raise this under a petition to rehear and say, look, this is based on either, and again, just to be clear, petition to rehear under Rule 39 is not even exhaustive of the options, but specifically numbers, I'll go off memory, 2, 3, and 4. All of these this issue still fits. Prior to even doing a Rule 11, it still would have been done. So there's no scenario I submit where it should have been ignored. And the other point I'll raise it to word it another way is this. When an issue is plain error and it wasn't raised clearly to the detriment of the defendant, what is the remedy? Is the remedy to say, well, we don't think that the trial counsel would have figured it out or could have figured it out? If that's the case, I don't know how it ever rose to the level of plain error. Plain error, in my position, believes is such an error that you don't get the luxury of saying, well, I didn't fully appreciate the issue because it was dicta. But even so, if that were the conclusion, there'd still be a problem because it could have been timely raised within the rules, which specifically provide for it, while the case was under appeal with the same trial and appellate counsel, specifically with the rules carved out by this court. Wouldn't have even had to get creative on making these arguments. So I think that is the end of the conversation there, I would hope. But the issue, I still want to go further as it relates to self-defense. Basically, trial counsel acknowledged that they use self-defense as their theory. So again, the argument is very simple. If self-defense is your theory, then you at least ask for a jury instruction on self-defense, and if you don't get it, you press it. Because the defendant is testifying with the belief and understanding that he's basically confessing to doing something presumably illegal, but the reason being is because there's going to be a jury instruction on self-defense. So when that jury instruction isn't given and that's your defense, I'm not sure what's the point of even having him testify or not telling him, hey, you can testify, but there's no scenario where I'm going to be raising that as the defense. And again, there was testimony at the post-conviction hearing that was in fact the defense. The motion to suppress issue, I think, was telling because it does not appear that the affidavit or the search warrant was included with the initial appellate record, so we know there was an error. There's no question there was a mistake. That should have happened. It did not happen. It could not have been fully considered. So now we ask ourselves, to what extent was this error? To what level did this hurt the case? Well, it hurt the case significantly because we cite to the search warrant and show that there's what we would suggest, and it's spelled out in the brief, material misstatements and misrepresentations in the search warrant, specifically as the time and when they're saying this event happened, when the defendant was alleged to have made it to the hospital, if he gave them a fake name or not. All of these things are necessary in concluding whether or not there's probable cause to issue the arrest. And so when these issues are not addressed and spelled out and they're left unanswered, that's clearly to the defendant's detriment. There was no strategy in forgetting to submit to the court the search warrant, or the affidavit request for it. So there could be any arguments about this being strategic or something intentional. It was clearly an error. The only question is, was it to the defendant's detriment? And I think it clearly was, because I believe that with the mistakes in the search warrant, it draws into question, would it have ever been granted to begin with? So I think those are important. And then the chain of custody. I believe the argument appears to be that there is no concerns or issues with the chain of custody, but there is. The brief goes on and explains how evidence was just misplaced, or we don't know where it was for significant long periods of time, and the jurors should have been informed and instructed that there is a such thing, that the state has to keep this chain of custody, and that when those are significant errors to chain of custody, then they need to rely on that when addressing the evidence, and the motion to suppress should have also been raised on that specific issue, because as we still stand here now today in this moment, we still don't know what happened to the evidence, where it was, who had access to it, how many times was it opened and resealed and opened again, and all of these questions. These are vital questions to this case that are left unanswered, and they're unanswered because of the way the state handled and dealt with this evidence. That should not be something that the defendant gets penalized for. He's brought these issues timely and appropriately before the court. And so we believe that based on these things, that the fairest thing and the only real remedy to do would be to remand this matter so that he can have a new trial. If nothing else, it gives us all a peace of mind that the justice system is in place and working. He was convicted under premeditated first-degree murder with there no question that the premeditated instruction was in error. If opposing counsel is correct and it would make no difference and it doesn't matter, then why not have a trial with the proper instructions and go from there? That's what we're asking for. We think that's what would be fair. That would put all of our minds at ease. And if there's no further questions, we ask that
This offense was videotaped,
correct.
and not only video, as I understand it, there was audio, correct?
I'm not sure about the audio, but I know for sure it was a video, and the defendant testified. So there was a lot of what happened. A lot of what happened came out.
How do you overcome prejudice at this point?
Prejudice to who?
How is the?
Oh, how is the defendant prejudiced is what
Yes,
you're saying?
yes.
Well, I think it's obvious by looking at the charges, and this is what I mean by that. The defendant testified, and his credibility was judged with everyone else. And this is I promise you I'm answering the question. After he testified, and after the jury weighed what he had to say, they did not convict him under felony murder. So if he went there to commit a felony and this person died, that's a conviction, and he would have been convicted of first-degree murder under felony murder. The fact that he was not convicted under that tells us that even with that video, when they heard what he said and they looked at the evidence and they weighed it all, they necessarily did not conclude that it equated to him just going there intending to commit a felony. Because if that were the case, and if that's what the video showed, and the jury believed that was the full story, then there's a conviction under both. And then when there's a conviction under both, then I have less of an argument to say the premeditated instruction matter, because then you would politely tell me, well, Mr. Tootin, well, what about the felony murder? And then I'd talk about something else until the time ran out, quite frankly. But that's not what happened here. I think that is telling. The fact that he did not get convicted necessarily means the jury says he didn't go there to commit a felony. So,
Well, they didn't say that.
well, but they did not say it. So that's the problem. And I think that's, and again, we were.
But they hung though, right?
They were hung, and that's the
Well,
point.
So
So
you
we
don't know,
were.
you don't know if it's just one person that hung.
I believe it may have been, but we weren't back there. I don't know where they started off. It could have started off 11-1, not guilty. We don't know. I mean,
How would you answer, I think the state says that the instruction suggests certain things that a jury can consider for purposes of premeditation, yet none of those seem to apply in this case. So how does the fact that the instruction doesn't have anything in it that would apply to the scenario in this case?
and that's the point. We don't know, and we can't agree to that, because this is the same jury, again, who we looked at a video and they reached a conclusion different. I mean, so you have what was testified to, what was on the video, and the jurors reached conclusions. We don't know where they reached and how they reached it, or what they did, or how they started, or where they ended. But again, I don't know how good of a practice it would be for us, specifically the court, because I don't have that level of authority, to say, we understand this instruction is erroneous. We understand that when you remove the premeditated instruction, you don't end up with a conviction, and then turn around and say, but couldn't have been any impact, it must have been harmless. I think that's a hard one to do. And again, you don't have to think about me or the defendant. Think about the public when they're dealing with these cases or looking at the justice system and how they would feel to say, well, wait a minute, everybody conceded that the instruction was improper. When you remove the instruction, he doesn't get a conviction, and everyone just shrugged their shoulders and said that doesn't mean anything. That is a hard pill for anyone to swallow. And I think, again, if there's no big deal and it's no issue, everyone should be thrilled with just remanding this back and see where we end up. According to the state, if this is the case, they can't lose. All we're doing is ensuring everyone has confidence in the justice system, and we're not risking anything. We're just protecting everybody's rights. So if they genuinely believe that, I would hope when I sit down, they don't argue anything other than to say, you know what, let's remand it back. I am that confident in this
Well,
case.
I think trial counsel admitted it was pretty damning what the video showed.
Well, trial counsel was also being post-convicted. So, I mean, it's not a lot. I didn't suspect him to get up there and just roll over and say, hey, there was nothing wrong. I mean, I'm not offended that he said that, but again, his position is his opinion, and he has a right to it. The jury had a right to their opinion, and we're here because the jury's opinion was that we're not finding the defendant guilty of felony murder, which means we did not conclude unanimously that he went there to commit a felony and while being there, killing someone. So I don't know if the trial counsel, based on what he said, would have reached that conclusion on count 2, but that was the conclusion reached. So I respect his opinion, but it is his opinion. But trial counsel, if we're going to give his opinion the proper weight we want to give it, that's the same trial counsel who acknowledged that I would have raised this issue if I was better aware of it, and that he didn't offer any justification for not raising it. And so, I mean, if we're going to give him the weight, let's give him the weight consistently throughout, and I think we still end up at the same spot with the unanimous ruling of remanding this back so that he can have a trial on this issue. Thank you.
General?
Good morning, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgment of the post-conviction court here because trial counsel was not ineffective. And because trial counsel was not ineffective, there is no need to remand this for a new trial. Turning first to the issue of the jury instruction on premeditation, the first question is whether it fell below an objective standard of reasonableness for counsel not to find and raise the argument in Compton. And the answer is that's not objectively unreasonable. Judge Wilson, as you kind of mentioned, this was an unpublished case, and the court's addressing of the jury instruction issue, it was dicta in that case. And counsel is not required to be able to sort of look into the future and try and anticipate possible changes in the law or to look into the future and raise those challenges to provide the effective assistance of counsel here. But even if we wanted to go to the second prong, prejudice, there is no prejudice here from the lack of the jury instruction. Judge Easter, you were asking about the video. There was a video that did include both audio and video. Trial counsel described it as extremely graphic, and trial counsel said that was a really difficult thing to overcome. And
Identity was never an issue, correct? I mean, it was this defendant in that video.
right, and he also testified too, essentially putting himself in the store. He admitted it was him, that he was the person that fired the gun. And trial counsel said that that sort of forced him to pivot in his defense strategy. He was initially going to try and make this an issue of identity, but once the defendant testified and confirmed that he was the shooter, that made trial counsel's job that much harder. But it was the jury who was also listening to the victim, as I think trial counsel described it, as gasping for breath and trying to crawl away. And then you see the petitioner who's about to leave the store. He comes back, removes his face covering, and then fires what's likely the fatal shot. So the jury, having seen all of that, coupled with the defendant's admission that he was the person that pulled the trigger, the jury instruction here really just did not have any, the verdict was surely unattributable to the error. And Judge Montgomery, you were sort of referencing the state's argument and the post-conviction court's finding here that most of the factors in this instruction really wouldn't have applied to the proof, so there really isn't the danger here that the jury would have considered something that it shouldn't have. And that argument really, I think, follows the way this court analyzed the sufficiency of the evidence on appeal, where the two things the court looked at were the fact that the petitioner was about to leave the store but then returned and fired the final shot, and then that he failed to render aid. That was another thing. He never called the police, never called anybody to try and help the victim, and then he got to the hospital where he gave a fake name to police and to hospital personnel, and then he fled the country once he was discharged. So based on all of this evidence here, the petitioner has not shown that the jury instruction caused him prejudice, and he's therefore not entitled to a new trial. And one final point on this issue, The mistrial, the hung jury on the felony murder charge, it does not demonstrate prejudice. That just shows that the jury couldn't agree on whether the state met its burden of showing that this was a killing committed in the perpetration of or attempt to perpetrate a robbery.
Do you think we're allowed to even consider that?
And no, Your Honor, I don't think you are, because we simply don't know anything about the jury's rationale. But one I would point out too, this was, the state's proof on the robbery was rather thin. So I think that does sort of explain why the jury might have hung there and then convicted him on the charge of premeditated murder when they had a video containing an audio and a visual of the shooting. But then turning to the remaining issues, trial counsel was not ineffective regarding self-defense here, whether it was to request an instruction or whether that was the actual theory of defense. I know trial counsel did at one point, I think he mentioned the word self-defense, but he also said that he would rely on the record more than his memory to describe the defense he raised for the petitioner. And what the record and what the post-conviction court properly found here is that self-defense was not the theory. This was not the defense theory that trial counsel pursued. He couldn't have, because the defendant explicitly and repeatedly testified multiple times that he wasn't acting in self-defense. He admitted that he shot the victim, that he shouldn't have shot the victim, and that he deserved some punishment for it. So counsel reasonably then tried to argue that while he committed the shooting, the jury should convict him of a lesser degree of homicide. So that's what the record on direct appeal, the trial transcripts really bear out, is that self-defense was not the theory here. The petitioner also testified that he had discussed whether to testify with his attorney, that he had the ability to make that choice after consulting with his attorney, and that he wanted to testify to tell his version of events. So the idea that counsel sort of coerced him or tricked him into testifying is just really not supported by the record here. And again, the proof would not have supported a defense on, or it would not have supported a jury instruction on self-defense based on the defendant's own admissions. And there was also nothing unlawful about the victim's use of force after the petitioner came into the store pointing his pistol at the victim. And by the time the fatal shot was fired, the threat had ended. The victim was on the ground and he didn't have his gun anymore. So even if counsel had requested this jury instruction, the trial court would not have provided it. Turning to the motion to suppress issue, what counsel testified to at trial is that at the post-conviction hearing, is that he likely reviewed the warrant and then chose not to challenge it because he didn't see any problems with it. And that demonstrates that counsel made a strategic choice about what to include in his motion to suppress. And there's nothing here that shows anything about the warrant would have led to a viable motion to suppress here. The sort of alleged discrepancy between the time that the petitioner arrived at the hospital doesn't invalidate the warrant. And the post-conviction court explicitly found that petitioner's testimony less than credible on the issue of whether he gave a fake name to police and to hospital personnel. So there's just nothing here that would have given any basis for trial counsel to successfully move to suppress the warrant. And then regarding the chain of custody, the jury was well aware of the chain of custody of this piece of evidence, which I think is the buccal swab of the defendant's DNA. Two officers explained where they found that envelope. They explained that it was still sealed, and they explained how it had been mislabeled. So the jury was aware of sort of everything that happened with the chain of custody with that swab. And as the post-conviction court properly found, there was just no basis for suppressing that swab. And unless there are any further questions on this, we would rely on our brief and ask this court to affirm the judgment of the post-conviction court. Thank you.
Mr. Tootin?
Just to kind of go where opposing counsel went, just to kind of follow behind him, this notion that trial counsel didn't do anything that was objectively unreasonable. You've heard me argue, I won't beat a dead horse, but what I will say is when you commit plain error, that is objectively unreasonable. This statement about, well, you can't look into the future, I agree with that. Some people say they have that gift. I'm not saying that trial counsel is required to have it, but I'm not asking them to look into the future. I'm saying stare into the past. Prior to the opinion being filed, again, which we heard no comment on, the ruling came out that we sent a vouch for. The Sykes case, it existed. Didn't have to look into the future. All you had to do is pick up the case and read it, or online, scroll through it, and then you address it. You could have addressed it prior to the opinion, but again, even if you didn't do it prior to the opinion, what's the point of having Rule 39 for the petition to rehear if we pretend like it doesn't have any weight? It specifically addresses this issue, so it could have simply been raised then. So no, we're not asking them to be psychic. We're just saying, look at the case law that was there. To go to the question about can you even consider the jury being hung on the felony murder, I think you do.
How?
Well, because it's part of this record, because one of the things we do know is that he was convicted with an erroneous premeditation first-degree murder instruction, and he was not convicted under first-degree murder when the premeditation was not presented in that way. So I think you have to consider it to say, if I don't know anything else, I know with the instruction in error, there was a conviction. Without the instruction, there was not. I think that's fair game for your honors to consider it. Now, again, none of us can know exactly what the jurors were wrestling with and deliberating on, but it is an undisputed fact that there was a conviction under first-degree murder where the premeditation instruction was improper, and no conviction under the first-degree murder when the premeditation wasn't there. And I do think that's fair for you all to take notice of. As it relates to the self-defense and saying this argument that there was no basis to support self-defense, all I'd say to that is that would have been nice to tell the defendant that before having them testify, since you're telling us under oath at the trial or at the post-conviction hearing that was your theory. If nothing else, based on that argument, to agree with that argument, you would necessarily have to conclude that that was ineffective assistance of counsel, because the defendant is testifying with the belief that he's going under self-defense, and it sounds like the state is vouching for the trial counsel to say that would have never been the theory. So again, it would have been nice to let the defendant in on that secret, and a failure to do so caused him to testify, not having the protection of an instruction that was never going to be pursued. That actually proves our point. And then the search warrant saying that was intentional or it was strategic, I submit that, and again, I'm a defense attorney, I can speak to this, it's never intentional to raise an issue with the appellate court and then forget to attach the affidavit or the search warrant with it. That's a mistake. Thank you.
Madam Clerk, do we have anything else? We'll be in recess then until 1:30.
All right.